Hi, my name is Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues here in Michigan. And today we're continuing our video series designed to educate and inform the public, so please subscribe to our channel. Today I want to talk about a specific issue about what do you do if you have a court-ordered parenting time and the other parent won't cooperate. That is to say, you're supposed to have time with your child and the other parent won't allow it, is ghosting you, is not doing what the court ordered. There are remedies for someone in that situation. The court doesn't know that this is going on, of course, until such time as you let them know. And the way you let them know is by filing a motion. The motion is typically a motion to have the other side held in contempt for violating the court's order. That's normally how these things take place. You would get the court to order a show cause why they should be held in contempt, and the court would set up a hearing. There's another possibility, and that is to go directly to the friend of the court, knock on the window, and say, look, this is the problem that I'm having. What can you do for me? There are pros and cons. If you do the latter, it's going to save you money because the friend of the court, it doesn't routinely charge for their services, okay? They're supposed to be available to the public and maybe specifically to help out with parenting time issues. And that's their highest, best destiny. So they're supposed to do that for you. However, as an agency, as a situation where you're not paying them, you're going to be in line with everybody else who has the same problem, who's come there for free help. So you might not get a hearing before a judge. You might not get an audience before even a friend of the court referee for a very long time. You'll get the first available date, but who knows when that will be. If you go before a judge and you set it up through a private attorney who will file the appropriate motion, you're going to get on the court's docket either that week or the next week. If normally the court hears motions on certain days. So let's say, for example, you're in Macomb County Circuit Court. They tend to do their motions on Monday. You've got to file it a week before. So if you don't file it till Tuesday, you won't get on that Monday. You'll get the following Monday, though. In other words, it'll be quick, but you're going to pay for it. You're going to have to hire a lawyer to use his P number and his skill and ability to draft that motion and file the appropriate, what we call a motion precipice, and get you on the docket. That's what you pay for. Now, a lot of people say, well, I had a lawyer, but it was too expensive. This is a thing we commonly hear, or my lawyer didn't do anything for me. That's a common complaint that we hear also. It's usually an inaccuracy. It's usually not that the lawyer didn't do anything for them. Sometimes you go before the court and the answer is no. Every single time you file a motion, the court's either going to grant it or deny it. And if they deny it, it's not that your lawyer didn't necessarily do anything for you. It's that the court felt, all things considered, that it's going to leave things the way they are, or it's not going to take any action right now. Maybe that's all it means. Or maybe it means that your lawyer never filed anything and never appeared, and that was just wasted money. Those are all the possibilities. The point is that you hire a lawyer, you're going to pay him money, and if you want him to do something on an emergent basis, you're going to expect that you're going to have to pay that lawyer even more, because what you're really asking him is to stop what he's working on, stop what he's doing, jump ahead of the line of his clients to file something on an emergency basis. An emergency basis, he'll be glad to do it, but in most lawyers, and I'm telling you this so that your expectations will be reasonable, in most law firms, they'll give you time to pay. However, they're going to require that you be paid up on your retainer before they file stuff. So if you're starting a new case and you've got time, the lawyer may say, okay, I'll tell you what, it's $3,000, but you pay me $1,500 now. I need time to put the paperwork together and file it anyway. When we're ready to serve, you got to pay me the other $1,500. So there's time. But if you come in on Monday and you need something filed by Wednesday so you can get on the next Wednesday's docket, you come in with an emergency. He doesn't have the time to say to you, okay, give me some of this now. It's got to be paid up, because once he files an appearance and tells the court I'm representing them, I'm representing so-and-so in this case, he's stuck until the court lets him out. And he doesn't want to be stuck if you haven't paid him. That wouldn't be fair to the law firm. So a person will find that law firms are reluctant to get involved in emergencies unless they are actually fully engaged to do so. Not to mention, but when you file these things, the court says, are you the attorney? Are you the point man on this? Are you going to be in on this case? Are you the one that our office is going to interface with till this emergency is resolved? And the lawyer's going to say yes. And if he's been paid, he can honestly say, with a clear conscience, yes. And if he hasn't, he really never knows whether or not you're coming forward with it, you're not. Can you be relied upon? Won't you be relied upon? It puts him in a very, very sticky position. So this is how these things work. The bottom line is, if you have time, most lawyers will work with you financially to get things done. If you don't have time because you're in crunch mode and need an emergency filed, expect that the lawyers are probably going to want to be fully funded on that so that they know the money's there to support the emergency work that you need done. If you have any questions about that, reach out. We'll be glad to help you out.